During the New Deal era, as we have seen, the Supreme Court reinterpreted the Commerce Clause of Article 1, Section 8 to increase Congress's powers substantially. The court then expanded that power still further in 1942 in Wickard v. Filburn. The country thus entered the period after World War II with a newly strengthened federal government. As the nation's population and economy grew, Congress began to use its power to address a variety of pressing societal issues, and the court faced the question of just how far the Commerce Clause would allow Congress's power to reach. One of the most famous examples is in the area of civil rights. As you may know, the United States remained a very racially segregated society well into the second half of the 20th century. In many parts of the country, African Americans faced terrible discrimination, and in some places, especially the Deep South, segregation was the official policy of state and local governments. We're going to look at the problem of racial segregation through the lens of the 14th Amendment's Equal Protection Clause in a later lecture, covering, among other things, the court's famous 1954 decision in Brown v. Board of Education, which held racially segregated public schools unconstitutional. But the problem of segregation is relevant to our continuing exploration of the Commerce Clause because the court's rulings in Brown and other important equal protection cases actually changed little for African Americans on the ground for many years. It was to address this situation that a full decade after Brown, Congress passed the Civil Rights Act of 1964. And it was the Commerce Clause that the government used to justify many parts of that statute. You may well ask why. A statute about civil rights certainly seems like it has more to do with concepts like equal protection and basic fairness than with the sort of economic matters that would seem to be at the core of the Commerce Clause. A more plausible constitutional provision to justify the Civil Rights Act might therefore be Section 5 of the 14th Amendment, which empowers Congress to pass laws enforcing the substantive provisions of the 14th Amendment, including the Equal Protection Clause. When Congress sees violations of the 14th Amendment, it can legislate under Section 5 to try to prevent or remedy those violations. The problem with using Section 5 to support the Civil Rights Act, however, was that some important 19th century precedent had construed that section narrowly. Specifically, in an 1883 case called the Civil Rights Cases, the court had held that Congress can only legislate under Section 5 to address governmental violations of rights. But segregation was not just a product of governmental decision. To be sure, there was state-sponsored segregation, and Congress pretty clearly could use Section 5 to pass a law addressing that. But many private white businesses also practice segregation, denying African Americans a wide range of services at businesses such as restaurants, theaters, and hotels. Many provisions of the Civil Rights Act of 1964 dealt with this private racism and exclusion. The lawyers at the Department of Justice defending the constitutionality of the new Civil Rights Act therefore faced a dilemma. These provisions of the Civil Rights Act sounded like laws dealing with rights, the kind of law that would fit under Congress's Section 5 powers. But if the court was going to uphold the Civil Rights Act on Section 5 grounds, it would have to first disrupt case law nearly a century old. It's always risky to bet a case on a legal theory that would require the court to overturn precedent, especially precedent of such long standing. The lawyers therefore turned to Congress's commerce power, which they knew under existing case law was broad. The challenge was to persuade the court that the Civil Rights Act implicated commerce at all. The most famous case here is Heart of Atlanta Motel v. United States. One provision of the Civil Rights Act prohibited discrimination on the grounds of race in certain places of public accommodation. In other words, the statute forbade certain privately owned businesses, like hotels and restaurants, from refusing service on the basis of race. To most of us today, this principle seems to embody basic decency in a civilized society. But in the mid-1960s, many businesses still refused to serve African Americans. The key question in the Heart of Atlanta case was whether Congress's law, which prohibited hotels and motels from denying service on the basis of race, was a constitutional exercise of Congress's commerce power. The motel contended that it served local clientele and that it was therefore beyond the reach of federal authority. The court disagreed. In an era of the automobile, people were increasingly mobile and traveled from state to state. Racial discrimination in places of public accommodation, the court found, discouraged African Americans from traveling. It's exceedingly difficult to travel away from home if hotels and motels won't serve you. Responding to the motel's contention that its discrimination would not affect interstate commerce, the court drew on Wickard v. Filburn, which we previously discussed. The court said that motels and hotels' practices of discrimination collectively affected interstate commerce by discouraging African Americans all around the nation from traveling. Thus, as in Wickard, the court looked not just at the effects on interstate commerce of the regulated party in this case, but rather at the aggregate effects on interstate commerce from all similarly situated parties. In other words, the court didn't only ask if the Heart of Atlanta Motels policy affected interstate commerce. It asked whether similar racially discriminatory practices from countless hotels across the nation did. A companion case called Katzenbach v. McClung involved Ollie's Barbecue, a Birmingham, Alabama restaurant that served white people at tables in the restaurant, but required its black customers to use a takeout window. Though the restaurant contended that it was a small local business serving only local clientele, the court followed its own reasoning from the Heart of Atlanta case. Discrimination in restaurants, like motels, has a direct and highly restrictive effect upon interstate travel by African Americans, the court said. At quick glance, the Ollie's Barbecue case might have seemed harder than the Heart of Atlanta case. After all, some restaurants really do serve primarily or even exclusively local clientele, whereas most hotels serve at least some out-of-town folks. The connection to interstate commerce, therefore, wasn't quite as obvious for Ollie's Barbecue restaurant as it was for the Heart of Atlanta motel. But in both cases, the aggregate effect of the racial discrimination severely impacted African Americans' ability to travel, which in turn had a substantial impact on interstate commerce. Moreover, as the court noted, much of the food served at Ollie's Barbecue originated from out of state, thus further implicating interstate commerce. In upholding the relevant provisions of the Civil Rights Act under the Commerce Clause, the Supreme Court indicated that it would review Congress's exercise of its commerce authority very deferentially. In the Ollie's Barbecue case, for instance, the court said that Congress had a rational basis for finding that racial discrimination in restaurants had a direct and adverse effect on the free flow of commerce. In requiring that Congress only need to have a rational basis to connect racial discrimination to interstate commerce, the court signaled that Congress doesn't need tons of evidence on the connection to interstate commerce. So long as it's not irrational for Congress to think there is such a connection, the court's going to uphold the statute. Most people today find segregation and racial discrimination abhorrent, but some critics question whether the court was correct in upholding these provisions of the Civil Rights Act under the commerce power. After all, we all know that Congress's primary motive behind the Civil Rights Act of 1964 was not really economic, but moral. The court, however, signaled strongly in Heart of Atlanta Motel and Katzenbach v. McClung that Congress's motives don't really matter so much. So long as Congress regulated activity that had a substantial impact on interstate commerce, Congress could invoke its Commerce Clause authority, even if its primary reason for acting had little to nothing to do with commerce. After these cases, it appeared that Congress had almost unlimited power to legislate under the Commerce Clause, and critics complained that Congress acted as though it could do anything. In more recent years, however, the court has cut back somewhat on this power. For instance, in 1995, the Supreme Court in United States